this week's episode of Your Business with Accent Nominees. My name is Daniel Olukayode Adeyemo, and today we'll be looking at shareholders agreement in business guides for startups. Alright, several weeks ago we looked at several agreements you would consider, in your business, and we, in the course of going through all of those agreements, we skipped one. Alright, and which is a shareholders agreement, and in a very short while you'll be seeing why it is important and why it's quite important that we share it with you. Alright, so first of all, you need to understand what is a shareholders agreement. Just the way it sounds, just the way it is said. It's an agreement between shareholders. Basically, it governs their relationship. It looks into, of course, the management of the company. It's in that agreement that you would state the modus operandi of that company or business in particular. And it states how the shares of the company will be acquired, transferred, or transmitted. So that's one of the terms that's actually contained in the agreement. It also protects the shareholder. Alright, so one thing we should know is that this contract or this agreement, it is largely known as a pre-incorporation contract, meaning it ought to be entered into before your company is incorporated. Alright, but no worries if you didn't know about this beforehand. Now you know, you can still make do with this knowledge you're getting right now. Alright, so in other words, like I said, it's a pre-incorporation contract. Means you must enter into this contract before you commence business, because it is for the good of the company, it is for the good of shareholders that are involved in the administration of the company, provided they are directors as well. Alright, so let's look at the importance of a shareholders agreement. So, well, the truth is, we have a lot of businesses currently operating without a shareholders agreement. I won't doubt that. Alright, it's a possibility, meaning in itself it's not compulsory, it is optional. Alright, but we also need to understand that despite it being optional, there's a lot to gain when you actually enter into this agreement, when you have this agreement in place for your business, for your company. Alright, so now one thing we should also note that in terms of its importance is that it's more like a legal means for protecting the interests of shareholders in the company, in the business. And of course, when we talk about the interests of shareholders, we're talking about their investment. Alright, so it protects the interest of shareholders in the company. Now, another is it addresses certain risks that can only be found in a shareholders agreement. Now, kudos to the founders agreement, the articles of association, which is more or less known as the rules and the constitution of a company. Kudos to them. But then there are certain risks, there are certain provisions that are not provided in those two documents that you would find that that would be ordinarily found in a shareholders agreement. So it's quite important that for these two reasons, you consider entering into one, creating. Alright, another is that it also covers a plethora of eventualities, such as finance. Finance is a major thing in running your company. So finance, the management of the company, the modus operandi, how things go from step to step, the general operations of your company, and the dividend policy, how the policies guiding how, probably yearly, based on those who hold shares in the company. Is it going to be yearly thing? Are we going to be issuing out dividends at the beginning of our company, or is it going to be like after 2 or 3 years? All of those issues that surrounds dividends generally are also involved, are also put into the contract, which you would not ordinarily find in other agreements that we already treated in the past. Alright, so other than that, we also have the resolution of deadlock situations, and of course, there are times where you're trying to make a decision and then it's more or less like a 50-50, or where there's a disagreement of some sort. It's normal when you have a partner, it's almost normal that you would disagree on certain things. So there are provisions there to take you out of those rough seasons. Alright, we also have valuation of shares and the procedure for transfer of shares. So we're looking at some of these things subsequently. Now is another one is it prevents the prevalence of floodgates of disputes and disagreements, which I just slightly mentioned, between shareholders. So what this tries to do is to ensure that there is amicable settlement such that the relationship is not hampered negatively. All right, so let's look at necessary considerations and clauses you need to have in your shareholders agreement to have an effective one. You know, so we have valuation, and now before allotting shares to the to whomever you be allotting your shares to, it's very important that you actually value your company. All right, you value it reasonably. All right, so you determine the value, then from there you can also, okay, well, I'm issuing this amount of shares from time to time, depending on the people you are actually issuing the shares out to. So you need to value first before you now allot shares to the people you'll be allotting the shares to. That's very important. And a major importance of this valuation is that when it comes to a point where probably your company wants to go out of business, it's probably exiting, they call it exiting the business scene, if that's what it's called. At this point, that's when you have the issue of buyouts, right? So the value that will be placed on your company at that point will be determined. It will be solely determined on the extent of value you've already placed on the business while just starting out. All right, so that is quite very important. We also have payments or other consideration. So we're just talking about allotting of shares. So if someone is allotting shares to you, of course, there has to be it has to be like an exchange of value, right? So I'm allotting shares to you, you're passing on value to me. The value most of the time is money, of course, it's major. It could also be probably your wealth of experience in terms of your skills, your qualifications, what you can do, how you can contribute to the growth of the company. All right. It could also be the fact that you, as the founder, you contributed the business idea. That could also warrant you getting a particular amount of percentage of shares in the company. All right. So beyond money, of course, things of money's worth would qualify as form of consideration in exchange for shares in the company. All right, and bear in mind that your consideration must be smart. That is, it must be specific, measurable, acceptable, realistic, and time bound. All right, so it's very important that, and if you look at all of this, this acronym SMART, you'll be able to relate. It's relatable. All right, especially for the time bound. That is, how long? If you're for example, you're not giving money in form of your shares, which is very scarce to see, and let's say you are just let's say based on your qualification, you're a lawyer and you're a part of a startup and you can give advisory services. Of course, that is for how long will you be giving that those services, time bound? Is it for 4 years? Is it for 5 years? All of those things. So smart. You also have vesting clause. Now, this helps ensure that there's no just when shares are allotted, there are conditions that must be fulfilled in order to enjoy absolute enjoyment of that of the shares. All right. So where this one is absent, right, it brings about the fact that okay, the shares have been allotted to you absolutely, meaning there are no conditions you ought to fulfill. But once this clause is put in place, there are conditions that must be put in place for the sake of the company. All right. A very practical example is let's say shares were allotted to you, right? For it to be absolute, they will say, okay, you have to be in this company for like 4 years, which is quite common. 4 years could be a condition for you enjoying absolute ownership in that shares or in those shares. All right, so that is just like an example of a condition that would warrant you having access to absolute ownership of shares in a company. All right, we also have preemptive rights, and particularly in a private limited company, this is quite very common. It's a normal thing. So usually in a private company, unlike a public company, is for a restricted number of people. You can't go outside the number of people, which is 50. That is at least 50 directors. So what happens here is that in a situation where a person wants to pull out of the arrangement, let's say there are 3 or 4 shareholders that are also directors, and you're trying to, you want to sell your shares and you want to move on. What this preemptive right, which is also a clause, does is that it prevents a situation where you, as a shareholder, you go ahead and say, I'm going to transfer this to someone else outside of the arrangement. So what this is saying is that bring it to us that you want to buy my shares. let's say there are three of you and one of you wants to step out, offer to the two of them, like the two other shareholders, ask them, oh, are you interested in buying my shares? I want to pull out of this arrangement. All right. So other than you just taking down, just sending to someone outside of the private limited liability company, and even more, it's one thing they call this an anti-dilution provision or something. So what this does is that it prevents people that you didn't originally intend to come into your arrangement to be a part of your arrangement. I mean the company. All right. So it prevents strangers from coming in. And worst of all, if let's even say the existing shareholders do not want to buy it, for the fact that they don't want to sell it to someone else, some other person that they don't know, they could choose to buy it at the end of the day. So that's pretty normal. We also have the drag along and tag along right, which is also a clause. So what the drag along clause does is that in a situation where the majority of the shareholders have agreed that, okay, you know what, we are selling, let's say we are selling the company, or we're selling, of course, selling the shares in the company, meaning you're selling the company totally. All right. What this does is that in a situation where a minority shareholder is not cooperating, especially when the terms of the sale is quite valid on all grounds, it's not disadvantageous where they're able to sell everything, they're able to sell, they're able to bring the minority shareholders on board, and they're able to sell off all they need to sell off. So that's the role that the drag along clause play. And we also have a tag along clause. On the other hand, it allows minority shareholders to join in on the sale of the company's shares, thereby providing them with greater liquidity and protection. So what this one is saying, this one is actually even protecting the minority shareholder, in the sense that, let's say, it's possible that the majority shareholders could just be like, you know what, we want to sell our shares, and they don't want to move on, while they leave the minority shareholders, where they are. So in a situation where the majority shareholders, of course, they're selling their shares at a favorable price and all of that, what this tag along clause does is that it brings them along in such a way that the favorable price would apply to them as well, so that they are not abandoned, so that they all can sell their shares, and of course they can get the benefits, all of them, including the minority shareholders. That's the tag along right or clause. All right. So we also have the non-compete clause. And if you've been following us, I personally took that several weeks ago, the non-compete clause. You might want to check it out. So, but for the sake of what we're talking about, sorry, right now, what this seeks to do is it seeks to prevent existing shareholders or shareholders in the past, previous shareholders, from taking undue advantage of their position. One thing shareholders enjoy is that for the fact that they're in that position, they have access to trade secrets, intellectual property, all of those things, trademarks, and all of those things. They have access to all of these, the mode of operations that is within the organization. So in a situation where a person is living as a shareholder, what this clause does is that it protects the company from those shareholders from going ahead to share it with some competitors that would hamper on the competitiveness of that company in particular. So but also it has to be reasonable. You can't just say that, oh, you are leaving our company as a shareholder indefinitely. You cannot share whatever it is we operate based on with anybody, or all of those things. So it's not reasonable in that kind of a situation. All right. So for more on this, I would advise you check out our previous session on non-compete clause. All right. So it's important you check that out. All right. So we also have the deadlock and dispute. So this, for me, this is two-faced. There could be disagreement. On the one hand, there could be disagreement between or amongst the shareholders, and this disagreement, of course, this clause makes it such that whatever the disagreement may be is easily settled in such a way that relationships are not hampered, at least to the best of its ability. This is one thing the clause does. Also, on the other hand, there could be disagreement as to a decision, probably the 50-50, and they're trying to reach a conclusion to what is being discussed, whatever the decision has to do with. So what this does is that it provides for, it provides a way out in situations, like this, depending on the company, depending on what they're trying to agree on. All right. So it's kind of provide a means of compromise, on the part of either parties, in order to ensure that the decision is made and it doesn't hamper on the growth of the company negatively. All right, that would be that for some of the clauses we need to put in place. There are more. All right, so let's look at the benefits of a shareholders agreement. In the course of talking, teaching this, I've mentioned a few, and one is minority protection. All right, a lot of times, even in our real life situations, we have a situation where maybe a bunch of elderly people are gathered alongside maybe young people. Just maybe the young people actually even feel you can see you just see a situation where the majority or the elderly ones just say, let's do it like this. They will just, what do they know? That kind of situation. So it could also happen in a business environment, in a company. So it's very important that you have a shareholders agreement in place. This helps to remedy situations like this. All right, so bringing it down to what we're talking about, one thing the shareholders agreement does is that it requires that you in the shareholders agreement you require that when it comes to making key decisions in this company, every shareholder, regardless of their voting power, would be able to have a say, must have a say, or must be able to have a say in arriving at this decision. Now, it's very important that we know that. All right, so this is one way. All right, in such a way that the whole essence of this is that it ensures that the minority shareholders are not sidelined when it comes to making key decisions in the company. All right, so we have decisions like issuance of new shares, taking new debts, appointment and removal of directors, all of those things. They are key decisions that affect the company. So what this does is that in the shareholders agreement, right, it could be included that in making some of these decisions, everyone has the right, everyone has a say in this, regardless of your voting power. All right. Another is the majority protection, so it's balanced. Okay, so it's not like you're trying to say the minority shareholders could be funny sometimes as well. So there's a provision also for them to ensure that things are quite balanced. All right, so and we already talked about some of these things. There are two major clauses that helps to ensure that the majority are protected. We have the drag along provision, which ensures that in a situation where the minority shareholders are not cooperative, in is when in a situation where the minority shareholders are not cooperative, where the terms of, for example, the sale of shares, is favorable, is not disadvantageous to any of them. All right, so the drag along ensures that allows them to be able to bring them along and just go ahead with the sale of the shares, for example, amongst other decisions that maybe is being sought to be made. All right, so that's that on that. We also have another clause, is the preemptive clause, which we also talked about. It prevents minority shares from transferring their shares to a competitor or other party. That it prevents dilution of the arrangement on ground, especially for a private limited liability company. All right, so this is what this does, and we already talked about the preemptive clause, so you can link it up. All right, so we also have the confidentiality clause. Now, ordinarily in any agreement, you would have the confidentiality clause, which ensures that these provisions and whatever it is we do, for me, what's this clause again? The non-compete clause kind of links up with this in a way, because by virtue of the position you hold, in the company, you have access to certain trade secrets. You have access to certain operations that are kind of for the organization, which gives them an edge over other companies as well. So the confidentiality clause allows such a way that it protects the shareholders. All right, the shareholders that are involved in the agreement are protected by virtue of the confidentiality clause. What I have here is that unlike a company's articles of association, which is a public document, a shareholders agreement is governed by laws of confidentiality, which binds the parties involved in the agreement. So it binds the parties to the agreement, which are the shareholders. All right. We also have alteration now. Now there's this thing about when it comes to altering the articles of association of a company. All right. So in altering, unlike the article of association, the shareholders agreement can be easily altered. All right, compared to articles of association where you have to have a special resolution passed at a board meeting, moving to down to the part where you have to notify the CAC who would have to give their own approval. All of those moves in a shareholders agreement. Right. So as long as the shareholders agreement contains necessary provisions that affect that helps to push the company forward and also protect the shareholders. When it comes to alteration, you don't really have to struggle to alter the provisions of the agreement compared to what you would do to an article of association. All right. We also have management. So the shareholders agreement will usually contain the day-to-day, the modus operandi of a particular business. All right, how you do stuff, the day-to-day operations, the number of directors, the remuneration, all of those operational factors in a business. So they can be contained in the shareholders agreement. All right, we also have, for me, what caps it all is the increased chances of investment. So for me, a company that has a shareholders agreement, in a way, it depicts a level of professionalism. And for anyone that wants to invest in bringing out your books and your document, just presenting your shareholders agreement could be something that really encourages a potential investor in putting in cash into your company. So this cannot be overemphasized. All right, so we've looked at a few of these things, and despite, like I said, despite it being optional to have a shareholders agreement, the benefits are just great, and you cannot afford not to have a shareholders agreement. And peradventure you've actually started your business and you're already operating and you don't have one, I would advise you put one in place, for the sake of your business, for the sake of you as a shareholder, for the sake of the shareholders involved in the company, because days will come, there are days that will not be all so smooth, and then the provisions you've agreed to would be what will carry you through those seasons. All right, so well, that will be all for this afternoon session. I hope you've been able to pick one or two things from this. For me, the takeaway is that if you've not drafted, if you don't have a shareholders agreement in place, please try to do something about that. It's not too late for that, despite it being a pre-incorporation contract. Thank you for your time, and that will be all.